Planning Committee on International Development. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person in the room as well as remotely using the Zoom application. I'd like to make a few comments for the benefit of the members and our witness as well. Please do wait until you've been recognized by name before you speak. For those participating by video conference, click on the microphone icon to activate your mic, and please do mute yourselves when you are not speaking. Interpretation for those on Zoom is at the bottom of your screen, and you do have a choice of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be made through the chair. Now, pursuant to the order of reference of Monday, February 13th, 2023, the committee resumes consideration of Bill S-8, an act to amend the Immigration and Refugee Protection Act to make consequential amendments to other acts and to amend the Immigration and Refugee Protection Regulations. It is now my great honor to welcome the sponsor of the bill in the Senate. We're very grateful to have here with us the Honourable Senator Peter Harder. Senator, you will be provided
Mr. Chair, could I interrupt just very quickly to move a motion before the Senator starts so I don't have to interrupt his testimony afterwards?
By all means. Yes, Ms. McPherson.
Point of order, Mr. Chair. Point of order, Mr. Chair, that the witness is here and you gave the witness the floor. Mr. Chair, I think we only have this witness for 45 minutes.
I believe I have the floor, Mr. Chair.
Mr. Chair, this is highly unusual.
A
member of this committee does not get to move a motion.
You know, unfortunately, I would like to move this motion now, and I think you did give me the floor, so I'd like to continue to move that if that's possible.
By all means, Ms. McPherson.
So I'd like to move a motion for a committee study on what actions Canada should take to foster peace and respect for human rights and international law in the region of Israel-Palestine. The motion was distributed to committee members on April 20th. Mr. Speaker, this motion is supported by a number of faith groups, including the National Council for Canadian Muslims, many Christian churches and Jewish Canadians, and Canadian human rights and humanitarian organizations. Many of them are watching us this morning in the hopes that I will have the support from all parties to pass this motion. Today, as you know, is the first anniversary of the death of Palestinian-American journalist Shireen Abu Akleh. And the past days and weeks have shown that the region is as far from a peaceful solution as it has ever been, and that there are enormous concerns about human rights and respects for international law, including attacks on Palestinian and Israeli civilians. This is a very challenging topic, and it is one with heightened emotions and serious consequences for many people. It is also a topic that our committee has not studied for at least a few decades. And yet it is one that is not only important to many Canadians, but it's also integral to Canada's foreign policy. Canada has a role to play in fostering peace and justice, and with its new bid for a seat at the United Nations Human Rights Council, this makes a study like this all the more important. I understand there may be some discomfort with such a study. This is a difficult issue, but we are a serious committee, and I think we have a duty to listen and to learn from experts, to approach this subject with respect for each other and for all people, and to help find solutions that will lead Canada on the right path. I'm asking today for the support of all members here for this motion, that, pursuant to Standing Order 108-2, and in light of recent events in Israel and Palestine, the committee conduct a study on the actions Canada should take to foster peace and respect for human rights and international law in the region, that the study consist of at least 8 meetings, that the Minister of Foreign Affairs be invited to appear, and that the committee invite witnesses from Canadian civil society, international humanitarian organizations, and Israel and Palestinian human rights organizations, that the committee reports its findings to the House, and that pursuant to Standing Order 109, the government table a comprehensive response to this report. Mr. Chair, I would find it extremely troubling if members of this committee chose not to study something that is so important with regards to our foreign policy, if this committee makes a decision to once again decline to study something that is so vitally important, I would urge all of my colleagues to think very, very carefully about how they vote on this motion. Thank you.
Thank you, McPherson, and also thank you for reminding all the members that it is the anniversary of the death of Shireen Abu Akleh. Thank you for that. Now we next go to Mr. Jenis.
Thank you very much, Chair. My respected colleague has made some substantive comments about substantive issues. I do want to just quickly make some comments about process, though. Typically, committees set their agenda via discussion at the subcommittee on agenda and procedure. That's why we have a subcommittee on agenda and procedure.
Point of order.
Yes.
This is very much within the standing orders. This is very much to bring forward a motion in public is very much the practice, the usual practice of this committee. As the member knows, he has done this multiple times, bringing this forward. I'm more than happy to meet at the subcommittee to discuss scheduling, the number of meetings, have a conversation about witnesses. But I think to pretend that this is not usual practice of this committee is
not a point of order, Chair.
Thank you, MP McPherson. We revert back to MP Jenis.
Thank you. Thank you, Chair. And regarding the questions of order, I don't question the fact that members are entitled to move motions. I think there are circumstances where that has happened, especially when there's been long periods of time when the subcommittee has not been scheduled. My view is that the best practice for setting an agenda is still through the subcommittee. We have Senator Harder here for half an hour. Look, I think there are important questions raised by this proposal, but I don't think the idea that we would, there are a lot of questions that could be worked out.
Point of order.
But can I finish my comment, Madam McPherson?
I would be happy to just move directly to a vote so that we could save the time, the senator's time. We could move to a vote immediately.
Thank
Point
you,
of order,
Chair.
Mr. Chair. Madam McPherson does not get to make a point of order proposing to move to a vote when there are still members of the committee that would like to speak to the motion.
Thank you, MP Bendayan. Back to MP Jenis.
Thank you. Thank you very much, Chair. I've been speaking for about 60 seconds, and there have been 3 points of order. I think maybe that makes a case about, in and of itself, about the value of us trying to come up with a better process for having this discussion internally. With that in mind, I move to adjourn debate.
Point of order.
Is that the will of the committee? Yes.
Point of order. Mr. Chair, we I think Canada and the world is watching what's happening overseas now and in the Middle East, and I think we can all agree that we are quite disturbed with the violence that is occurring there, in both to both.
This is.
I'd like to have the floor.
I'm sorry, that's out of.
I'm speaking a bit slow, which maybe is allow me.
No, it's.
You're interrupting me. And
yes,
you don't have
Mr.
the floor
Zuberi,
either.
I'm sorry, but he did bring a motion to adjourn.
Mr. Chair,
Debate. Yes.
I have a point of order.
Yeah, that's fine. But this is not the time for a point because he's brought a motion to adjourn.
My point is that this is an important study, and we should be studying this.
Thank you. Is it the will of the committee to adjourn? Yes. No. No? Okay.
No.
So we will have to put it to a vote. Let's do a recorded division, please.
Thank you, Mr. Chair. So the vote is to adjourn debate on the motion moved by Heather McPherson. Mr. Sarai.
I'll abstain.
Mr. Oliphant.
Yes.
Mr. Zuberi.
No.
Dr. Fry. Dr. Fry?
Sorry, I voted yes. Thank you.
Yes. Madame Bendayan?
Oui.
Mr. Guinness?
Yes.
Ms. Kramp-Nyman?
Yes.
Mr. Obach?
Yes.
Mr. Epp?
Yes.
Monsieur Bergeron?
Non.
Madame McPherson?
Nope.
Yeas 7, nays 3.
Thank you for that. So now we will go back to Senator Harder. Senator, thank you for being here with us today. You have 5 minutes for your opening remarks, and when you only have 30 seconds remaining, I will hold this up. That is true not only for your opening remarks, but also when members ask you questions as well. Senator Harder, the floor is yours.
Hope I don't use all of my 5 minutes, but I appreciate your signals. This is an S bill, which means it originated in the Senate. It is a government bill, and it is not unusual for government bills to be tabled first in the Senate, although it's not a practice that takes place often. This bill was first introduced on May 17th of last year in the Senate and dealt with second reading on May 19th and went to committee for consideration on June 3rd and June 9th. We heard from approximately 19 witnesses from both officials and other interested groups and returned the bill with one technical amendment which coordinated this bill with another bill before this chamber at that time, Bill 21. And the final reading took place on June 16th, and the bill S8 was unanimously accepted in our chamber and hence sent here. So the bill before you is viewed from our chamber as an urgent piece of legislation, a necessary piece of legislation, which allows for sanction-related inadmissibility grounds to be treated in a cohesive and coherent manner. It will strengthen inadmissibility legislation that we already have in place, rendering designated persons subject to Government of Canada sanctions inadmissible. And it, in addition to that, has further coordinating mechanisms that are important in the view of the government, and I believe you've had the officials from the departments concerned here. And I would urge this committee to deal with this bill expeditiously so that this gap in inadmissibility can be addressed. This not only is urgent with respect to Russian nationals, but it is universal. So we'll deal with nationals of other sanctioned regimes, including obviously Iran. I'm open for questions. Again, the sponsor's role in the Senate is to shepherd the legislation through the Senate and in committee, and to work with colleagues and ultimately the government to ensure that the bill's carriage is both appropriately timed and succinctly and appropriately addressed by the Senate of Canada. So thank you for your giving me the opportunity. Usually we have the benefit of House of Commons reflection before we get a bill. Now you have the opportunity for what we call sober second thought.
Thank you, Senator. We will now open it to questions from members. And MP Hoback, you are first. In this round, each member will be provided 4 minutes.
Oh, thank you, Chair, and thank you, Senator Harder, for being here today. Senator Harder, from what I can see of this, is just mainly housekeeping, cleaning up to bring things in line. But there's one area that looks like to be an oversight, but maybe I'm missing something, so I'll ask you about it. It's on page 2 of S8. You are removing paragraphs 35(1) C to E, and C1 reads, having engaged in the conduct that would, in the opinion of the minister, constitute an offense under section 240.1 of the Criminal Code. And then if you go to section 240.1, the Criminal Code relates to trafficking in human organs and removal without informed consent. Why would we take that out? Is it encompassed somewhere else, or?
It is my understanding, and I'm not the official responsible, but that prohibition is included in the what was the coordinating legislation to which I referred, which would add transnational border criminality to existing grounds for inadmissibility or detention, and therefore it is captured in the coordinating approach that this bill is designed to achieve.
Yeah. I just want to confirm that. So, Mr. Epp, if you want to take the rest of my time.
Thank you, Mr. Chair, and again, thank you, Senator Harper. Een gouden dag. Ik denk dat het het eerste model gewoon plotisch reden.
Ik kon ook goed plotisch.
The first time, just for the benefit of the others, that was a Low German dialect that the senator and I share. You said that you had 19 witnesses in front of the Senate, and obviously you've become comfortable with some of the criticisms of the bill. So I'm going to ask some of the criticisms that have come our way have been around the definition or lack thereof of sanctions. Does the Senate feel that the definitions are appropriately captured in other legislation?
Thank you for the question, and I am glad that you didn't repeat the whole question in Low German, because my response would have been a little more tardy. The Senate took the view that this bill is about closing the gaps in existing measures. And that was the view taken by all senators, including many who are strong advocates of refugee protection. We have, as the Senate Foreign Affairs Committee, just completed a review of the Magnitsky Act as required by the 5-year review process, and will be very shortly issuing a report that deals with some of the broader issues, including ones that you've raised. And I hope that that gives an opportunity for this committee and the Senate itself to reflect on the recommendations that we come forward with.
And I assume that definite or that concern also relates then to entity or the definition of an entity or state entity?
Correct. Although I should say that we want legislation that is broadly permissive of government to rapidly act under regulation to deal with emerging entities.
Thank you. The bill also shifts ministerial discretion from the Minister of Immigration to the Minister of Public Safety. Can you comment as to why the Senate is comfortable with that shift?
Because border access is under the Minister of Public Safety, and therefore we're trying to ensure that the front line is appropriately addressing the issues for which they are responsible.
Concerns have come to our attention from the cost of redress or the availability of redress if it were to be people captured for inadmissibility are captured under sanctions. Any comments?
Well, redress is available through the Minister of Foreign Affairs, who has responsibility for the naming of individuals, and that redress mechanism is available.
Thank you. I believe I'm out of time.
Thank you very much. We now go to MP Sarai. You have 4 minutes.
Thank you, Chair. Thank you, Senator, for coming up and appearing before us on this very important bill. Senator, we know that the legislation was first introduced in the Senate, as you mentioned earlier, before making its way to the House. Has the Senate made any significant amendments to the original bill?
Thank you for your question. The Senate made one technical amendment, which was a coordinating amendment with which was then Bill C-21 here, to ensure that whichever bill was enacted first, there was a complementarity of action allowed. But we made no other amendments, nor any proposed, either in committee or on the floor of the chamber. The view of the Senate was that this was urgent, necessary, and ought to be done quickly, which we did a year ago.
Thank you. Senator, we're starting the study of this bill, and are there any elements of this bill, based on your experience, that we should pay attention to?
I believe that the responsibility of I cannot claim what the responsibility of the House of Commons is, but in the view of the Senate, the obligation we have is to close the loopholes that are identified and secure the inadmissibility regime that we have put in place and that has been tested and is being tested, and we would be very supportive of early implementation.
Thank you. In your speech during the second reading of Bill S-8 in the Senate, you started that under an Immigration and Refugee Protection Act, most individuals sanctioned pursuant to the special economic measures may nevertheless have unfettered access to travel to enter or remain in Canada if they are not otherwise admissible. Why is this the case that individuals sanctioned under CEMA can still travel to or enter or remain in Canada, and how does Bill S-8 specifically address this issue?
Well, they are not inadmissible under the law as it exists without this amendment. So what we are seeking to do, what the government is seeking to do, is to ensure that inadmissibility takes place at the front line early in the possible admission process. Because as you well know, once an individual passes that initial security check and border official, there are new processes in place for removal. So we are seeking to ensure inadmissibility is strengthened at the front line.
And are you aware of anyone that has traveled or entered or remained in Canada?
I am not, but I did ask that question of officials at that time, and they said that a small number have, in fact, and I didn't press it further for precise numbers.
You also, in your speech, had explained the bill aims to remove ministerial relief for individuals inadmissible due to sanctions, as well as their ability to appeal to the Immigration Appeal Division. And others, like the CBA, Canadian Bar Association, have argued that should provide a legitimate avenue of redress, given the severe consequences of inadmissibility based on sanctions. How do you respond to that, and what are your views in respect to that?
It is the view expressed in this bill and hence expressed by the Senate that sanctioned individuals ought to go through the appeal process of which is the sanctioning process, which is the minister responsible, which is the foreign minister, not through existing immigration processes that go before the Immigration and Refugee Board.
Thank you.
Now go to MP Bergeron. You have 4 minutes, sir.
D'abord, Monsieur le Président.
Chair, I would first like to say that I'm quite overwhelmed by what has just happened. There are people who are dying in Palestine, dying in Israel, and this committee chose to adjourn debate on a motion that would ensure that we consider this issue. I cannot understand why this committee, the Committee of Foreign Affairs and International Development, decided to adjourn debate on what is currently happening in Israel and Palestine. I'm completely overwhelmed by this. Now, I know you will call me to order, and you'll be right, but I just want to say that I am outraged that even the person who moved to adjourn the debate actually left immediately afterwards. Now, I know you're right, you're in calling me to order, but I had no choice but to say this because I just think it's absolutely unacceptable. I apologize, Senator. I am so upset over this. But now I'm going to continue regardless because that was the decision of the committee. So thank you for coming today. And thank you for having endured this for a few seconds. I put a question to the minister when we met him this week. I said, why was there a decision to go through the Senate? And he said that it was because of various procedural mechanisms, that it makes moving the bill easier, moving it forward. But perhaps you could enlighten me on the process. I have to admit that given that there are no more Liberal senators in the Senate, I'm rather, well, I think it's rather Byzantine. Actually, I'm having trouble understanding the procedures, and I'm troubled by this. I'm troubled by procedures that would allow you to come here this morning, but Mark Gold appears on the website as the sponsor or the mover of the bill. So could you just please enlighten me as to why you are here and you are considered the sponsor of the bill, which is actually a government bill? You're not a member of the government. Please explain.
And it's good that we have an early opportunity to engage in a bicameral way on what the processes are, particularly as the Senate of Canada has evolved to a less partisan, more independent approach. The first point I would make is it is rare that a government introduces a bill in the Senate for first consideration. That is why S bills are small in number. They cannot be bills that have any financial obligation attached to them. They are often used on matters that are viewed as important, urgent, and not controversial. So, for example, free trade agreements have been introduced in the Senate first. This bill was introduced in the Senate a year ago because the government felt that the agenda in the House of Commons was so charged and the bill was so necessary to signal the direction the government wished to go on inadmissibility, they used the Senate. Again, it is not often, but it is not without precedent. In the Senate, we have a government representative of which I was once one for the 4 years from 2016 to 2020. I served as the government representative, and that was the senator overall responsible for the management of the government's agenda in the Senate, and to, as a Privy Councillor, work with Cabinet directly in terms of the legislative agenda, as it particularly references the Senate. I am not in that role, have not been since 2020. Now, each bill in the Senate, the government representative seeks a sponsor. Unusually, it could be somebody within the government representative office. Usually it's not. And because of my interest in this area, I was the first executive director of the Immigration and Refugee Board. I was the first Deputy Minister of Citizenship and Immigration, and I was, before I left government, the Deputy Minister of Foreign Affairs, so I had some familiarity with the tools and mechanisms of what we are dealing with here. I thought it would be appropriate and interesting to sponsor this bill, and as I indicated in my opening remarks, the sponsor's role is to advance the bill and to work with colleagues to ensure the appropriate witnesses are heard, that the bill proceeds on a pace that wins the support of colleagues. And in this case, as I say, the bill was dealt with rather expeditiously, having been introduced on the 17th of May and ultimately achieved a third reading on, I believe, June 16th. So it is completely normal that we seek sponsors across the aisle. In my time, even a conservative senator sponsored a government bill, which is an indication of how less partisan our chamber is. I make no comparisons except to assert that we are comfortable with that approach.
Thank you, Senator. So, Mr. Bergeron, we're 2 minutes and 20 seconds over. Madam McPherson,
Thank you.
have
Thank
4
you,
minutes.
Mr. Chair. Thank you very much for being here, Senator. And I do just have to echo, before I ask you some questions, I do need to say that I, like my colleague, Mr. Bergeron, am extraordinarily disappointed by the decision made by this committee. And quite sickened, to be perfectly honest, that we have people across this country, around the world, that are looking to Canada for leadership, looking to Canada to build peace, and the Committee on Foreign Affairs refuses to look at that. And the member for Sherwood Park's Fort Saskatchewan
Point of order. Could the chair clarify, and it is a point of order, what it means to adjourn debate, and to clarify that does not mean the motion was defeated, but that the motion can be brought back. Could the chair clarify what it means, what we actually did today? Because the understanding I'm getting is as though we defeated the motion, which was not the case. Could you clarify that, please?
Correct in your interpretation, MP Oliphant. That does not mean by any means that it was defeated, and it can certainly come back.
That's an excellent point, Mr. Chair, because I want everyone who is so interested in fighting for peace for Israelis and for Palestinians, for people around the world that have been asking for this committee to take this on, that I will be raising this motion every single meeting so that the opportunity to pass it will be forward.
To S8, please.
Thank you. And one last thing I would just very quickly say is that the member for Fort Saskatchewan, Edmonton, or Sherwood Park, Fort Saskatchewan, left immediately following because I expect he wanted to get to the pro-life rally, which is another thing that he has filibustered in this committee.
Again, relevancy. Second of all, mentioning the fact whether the members here or not at the committee is not appropriate.
No standing order on them.
And third of all, we've got Mr. Strahl, who subbed in for Mr. Garnett. That's been planned all along. We knew Mr. Genius had other commitments, so...
you cannot name a MP
member from Fort Saskatchewan.
You can refer to their name. You can refer to their writing, of course.
So, but anyways, I don't think it's appropriate to go after a member in this fashion when he's not here to defend himself because he had other business.
And he should be here.
No, he's got work to do, and he does his work in his own
MP Hobach, I have to say,
order,
it is a
Mr.
question
Chair.
of relevance. MP Fry, could you please wait till you've been recognized, please?
Yes.
Well, I'm raising a point of order, Mr. El-Hassi.
That's correct, but you have to wait till you're recognized.
Until you
Dr.
recognize
Fry.
me, I know, but I didn't know if you could hear me over everybody speaking at the same time.
So, Dr. Fry, you have a point of order?
I have a point of order, Mr. Chair. We discussed what adjournment of a debate meant. It didn't mean people voted against the actual motion. I think we have witnesses who came here to be present on the topic that we're meant to discuss on the agenda for today, which is S8. I would like us to just continue, and I think it's inappropriate, as we all know in the House, to mention someone's absence or to suggest that they should be there when one does not know what that individual person's has in store that means that they cannot be there. That's a really unfair thing to do. Thank you.
Fry, we go back to MP. Yes, MP Strahl, do you have a? Did you?
Yes, on the point of order, Mr. Chair. I'm a guest at this committee, but I am. Substitutions happen all the time between members of Parliament. Mr. Genis is at Transportation Committee, my normal committee, doing the work of a parliamentarian. And it's outrageous that a member would use her platform to attack and impugn the reputation of another member. And I hope, Mr. Chair, that you will not allow this to continue in this committee. It's simply not true that he is at somewhere
MP Strahl,
else,
that's not a point of order, but thank you.
Well, it absolutely is a point of order, Mr. Chair. You cannot reference where a member may be, even if it's in your own imagination. And I would hope you would call that member to order.
Point of order. I just want to thank you, Mr. Chair, for managing this spicy committee and helping us to study very important legislation.
Thank you, MP Zuberi. We go back to MP McPherson. Can I once again remind you to remain relevant to the topic at hand?
Absolutely, and I will, as I mentioned, bring this forward in future meetings for us to discuss. Senator, I do apologize. I know that this is your time, and I did need to say that so that those that are watching this committee understand just how atrocious that behavior was. And I think we've discussed this. This is a very important bill. I think it's good that you've brought it forward. I'm happy that this bill is coming forward. I think our sanction regime has to have more teeth to it, more ability to hold those that we are sanctioning to account. So just a few very quick questions, I guess, for you. My understanding that there was only one minor technical amendment made to this bill at the Senate. So during the Senate testimony, did you hear similar concerns to the ones that were raised in briefs to committee that we will hear from shortly from the Canadian Bar Association, the Refugee Centre, and others? And we're just wondering a little bit why you didn't choose to accept more of those amendments.
Thank you very much. Of course, it's not my determination as to whether amendments are brought forward or accepted, but it was the collective will of the committee, who did hear those witnesses as well, in the amongst the 19 witnesses that we heard that we were not willing to move any amendments as they had suggested, and felt that the legislation, aside from the one technical amendment that I referenced earlier, ought to move forward expeditiously as it was both necessary and the subject matter of the narrowness of the bill that is before us. And that we as a committee felt that the Meninsky review, which we were about to launch, would be the appropriate vehicle to look at the broader policy issues, which we have.
One last quick question. Because there are some questions about, whether some things should be amended, would you support a review mechanism be put into this bill?
Look, parliamentarians can do what they will. My advice would be that this bill has been out of the Senate for now almost a year. I would like the bill to become law as quickly as possible, and therefore without amendment, so that the assurances that we speak to Canadians about in terms of inadmissibility and integrity of our borders can in fact be reflected in the law that the government has put forward.
Thank you very much.
Thank you very much, MP McPherson. That concludes the questions from the members. Senator, thank you very, very much for appearing before our committee. We're very, very grateful for this particular bill and also for everything else that you've been doing. Thank you. Now, we will adjourn for a couple of minutes. For those members online, you don't have to do anything. We'll just adjourn to allow the next set of witnesses to assume their seats. Thank you.
So.
We'll now resume the meeting. It is now my great pleasure to welcome before this committee various witnesses who are here in relation to consideration of Bill S-8. As individuals, we have Mr. Mario Bellissimo, a lawyer, a certified specialist with Bellissimo Law Group Professional Corporation. Online, we have Mr. Marcus Kolga, Senior Fellow at the Macdonald-Laurier Institute. We also have with us here from the Ukrainian-Canadian Congress, Mr. Ihor Michalchyshin, the Chief Executive Officer, as well as Orest Zakidalski, the Senior Policy Advisor at the Ukrainian-Canadian Congress. From the Canadian Bar Association, we have Ms. Lisa Middlemiss, the Chair of the Immigration Law Section. And from the Refugee Center, we have Mr. Abdullah Dawood, the Executive Director. So I will now open it up to opening remarks from the various witnesses. Each witness will be provided 5 minutes. When you're cutting it when you're very close, and I just want to indicate you should be wrapping up your comments, I will hold this up. And that applies not only to your opening remarks where you get 5 minutes, but also when the members are asking you questions. So that all having been explained, I will now go to Mr. Bellissimo, who is joining us virtually. Mr. Bellissimo, the floor is yours. You have 5 minutes.
Good morning. Thank you, Mr. Chair, members of the committee. Thank you for the invitation. In our brief submitted before the Senate last year, we made 5 recommendations, which we repeat here. We endorse the concerns highlighted by the CBA and the Refugee Center. So why our recommendation? Context is always important. The current law is potent. As the committee knows, the authority to render individuals inadmissible under the IRPA for international and human rights sanctions has been in place for over 20 years. Of the thousands of people currently on the sanctions list, we cannot identify anyone that would currently be inadmissible under Canadian immigration law. But what's the harm in adding more sanctions? The bad actors should have no access to Canada. We agree. Yet it is much more complicated. The IRPA's jurisdictional integrity, for one, is at stake. Why? Aligning all of Section 4, 1.1 of the CEMA with the IRPA introduces, just to list a few, economic sanctions, where recommendations to sanction result in automatic inadmissibility, and where investigations into sanctions could be grounds for detention without legal context and without relief from third-party adjudicators like the Immigration Division. That will now be repealed. In short, the new law, make no mistake, is too broad. It can impact citizens, permanent residents, and foreign nationals guilty of no wrongdoing. This is striking. Applicants, their spouses, and children would have little, if any, options left under the IRPA. Generational impact. So recommendation 1 is a requirement for legislative clarity. We've heard a lot about it. The word sanction remains undefined, but it's also been divorced from grounds of violating human or international rights. It's now a standalone, undefined ground for inadmissibility, which currently exists in the IRPA. Why? Is this not the harm we are targeting? Bad actors in violation of human rights or international rights? Section 35.1 must be connected to human or international rights violators. Key terms like sanction and entity must be defined in the IRPA. This is all very important because subject matter experts in the sanctions regime, like Dr. Andrea Sharon, and a prior Senate study, raised several acute issues, too many to recite here, but to mention a few about sanctions: the need for parliamentary oversight, better coherence and compliance, timely and independent redress avenues, accountability, transparency, and other practical challenges. For example, Canada continued to leave sanctions in place against foreign states like Liberia and Sierra Leone long after the United Nations lifted them, a legal purgatory under Bill S-8. This committee should address that regime, and I understand it's going to study, before the passage of Bill S-8. Put plainly, individuals' lives could be significantly altered by a law that potentially should not apply to them. Equally troubling, it may not exclude some of the bad actors because the law becomes immersed in legislative ambiguity and applicatory limitations, resulting in procedural and fairness concerns possibly rising to the level of constitutional issues. Recommendation 2, legislative clarity is also required for the Citizenship Act and the Emergencies Act. That has not been discussed thus far. Canadians should not be at risk of losing their Canadian citizenship on a precarious legal foundation. Same for recommendation 3, with respect to dependence. IRPA cannot lose its jurisdictional integrity by being restricted in providing relief where justified in the confines of its own act. Ironically, in the sanction regime, there's legislated exemptions, but really none remain for those involved in navigating the IRPA. Recommendation 4 underscores the need for overbreadth and excluding those with no personal wrongdoing or any transgressions or any connection to transgressions. Recommendation 5, we rely on David Mattis's brief before Senate. Granting of refugee status should result in immediate delisting. Access to refugee status should be uniform in and outside of Canada. We propose calling David Mattis and Dr. Sharon to testify. It is critical we maintain the jurisdictional independence of the IRPA and its harmonious intersection with other domestic international legislation for the objects of the acts and the clear intention of Parliament to be realized. To get there, Bill S-8 needs further study and amending. Thank you.
Thank you very much, Mr. Bellissimo. We now go to our second witness who's here as an individual. We go to Mr. Kolga. Mr. Kolga, thank you for being with us once again. The floor is yours. You have 5 minutes.
Well, thank you, Mr. Chairman and esteemed members of this committee for inviting me to testify today on Bill S-8 and Canada's sanctions regime. I had the privilege of leading the Canadian civil society campaign for Magnitsky legislation, during which time I had the honor of working with Senator Andrechuk, former Justice Minister Irwin Cotler, MP James Bazan, and many of you here today. That work also included cooperation with many of the leading post-Cold War era Russian human rights activists like Boris Nemtsov and Vladimir Kara-Murza, both of whom came to Ottawa to advocate for Magnitsky legislation. Boris Nemtsov was, of course, assassinated in February 2015 for his leadership and advocacy. Vladimir Kara-Murza was poisoned twice to within a hair of his life, and 2 weeks ago, he was sentenced to 25 years in prison for his criticism of the Putin regime and its barbaric invasion of Ukraine. My activism and advocacy for Magnitsky sanctions has also attracted the attention of the Russian government and its morally corrupt enablers here in Canada. And I'd like to take this moment to note the intimidation that the member from Wellington Halton Hills has endured for his leadership and advocacy against foreign authoritarians. His experience has finally forced a national spotlight onto the threat of transnational repression and the efforts of authoritarian regimes to silence Canadian advocates of human rights and democracy. For those of us who have long endured threats of violence, organized campaigns to discredit us, and dehumanizing marginalization based on our ethnic backgrounds, we shudder and we share the anxiety of our fellow Canadians who are victimized by foreign intimidation. The application of sanctions is a painful consequence to the corrupt officials and oligarchs whose stolen assets are used to fund lavish lifestyles and pay for the protection of totalitarian leaders like Vladimir Putin. Their threats and intimidation against those who advocate for them are a good measure of their effectiveness. Over the past 15 months since Russia invaded Ukraine, we witnessed a rapid and welcome intensification of our application of sanctions on individuals and entities linked to the Putin regime. All Canadian parliamentarians deserve credit for their unanimous support of sanctions, which has made Canada a leader in holding the Putin regime to account. Sanctions have been imposed on leading Putin-aligned oligarchs who have assets in Canada, like Roman Abramovich. Mr. Abramovich of Raw Steel owns 5 major steel processing plants in Western Canada worth billions of dollars. Kremlin-controlled propaganda outlets that pollute our information environment and that provide platforms for domestic far-left and far-right extremists like RT, Sputnik, Channel One have been sanctioned and removed from our public airwaves. However, some gaps remain. Bill S-8 helps address one of them, which is ensuring that those on our sanctions list are also denied entry into Canada. This is a very welcome amendment to IRPA and our overall sanctioning regime. Another significant gap is one that pertains to Russian state media and its continued availability in Canada's Russian diaspora community. Despite our sanctions on Russian state media, streaming devices and services, much like those offered by Amazon and Google, are sold in Canada by Canadian companies and provide access to multiple Russian channels sanctioned and banned by our government. Specifically, these channels: First Russia, Channel 1, NTV, Russia 24, and the many other channels that are controlled by the All Russia State Television and Radio Broadcasting Company, which is also on our sanctions list. Canadian far left and far right extremists continue to appear on sanctioned Russian state media channel, RT, where they legitimize Russian state narratives. If they receive any benefit, this may also represent a violation of Canadian sanctions laws. Finally, the acquisition of services related to tourism in temporarily occupied Crimea contravenes Canadian sanctions legislation. A Canadian far-left pro-Kremlin extremist recently boasted on social media that he met with Russian Foreign Ministry officials in Moscow and later traveled to Crimea on a tourist visa. While Canadians are free to travel as they wish, that does not mean that they are free from the consequences of contravening our sanctions. In conclusion, I strongly support the harmonization of IRPA with the Canadian Magnitsky Law and CIMA. Thank you so much again for inviting me to appear here today, and I look forward to your questions.
Thank you very much, Mr. Kolga. Your timing was perfect, I might add. We next go to the Ukrainian-Canadian Congress. It's a great pleasure to have with us here again Mr. Mikhailchishin. It is great to see you at committee. I think you're one of the most familiar faces here, and we're very grateful to have you back.
I'm earning those air miles coming back. Thank you. Well, thank you for the invitation.
So the floor is yours. You have 5 minutes, sir.
I wish we didn't have to be here so often, but today is day 441 of the Russian full-scale invasion of Ukraine. So it is good to speak with you today. With regards to this bill, S8, the amendments on individuals sanctioned by Canada and CIMA, we strongly support this legislation as drafted by the Ukrainian-Canadian Congress. We believe that together with the freezing of assets held in Canada, and hopefully soon the seizure of these assets, the inadmissibility of individuals listed under CIMA will be a key part of Canada's strong sanctions regime against foreign officials, whose regimes, as we know and have heard, are engaged in gross human rights violations and significant corruption activities against individuals who financially and politically support those regimes. We believe the proposed amendments to IRPA is a step, as we heard, in closing the statutory gaps in our legislation to harmonize CIMA with the Immigration Act and assist making Canadian sanctions more effective. So we call on the committee to adopt the bill quickly, and for our community, it is part of the ongoing effort to significantly strengthen Canada's sanctions regime. I will turn it over to my colleague to talk about two specific issues we believe can be addressed.
You have 4 minutes remaining.
Thank you. So the first issue we see with Canada's sanctions regime is the methodology by which our government decides whether or not to sanction someone. We've never really understood or received an explanation for why, for example, someone is sanctioned in other jurisdictions but not in Canada, and how the decision to not sanction someone is made here, or to not sanction someone sanctioned by our allies is made. For example, on April 6, 2022, the UK sanctioned Vyacheslav Kantor, the largest shareholder of fertilizer company Akron, with, as the United Kingdom stated, vital strategic significance for the Russian government. On April 8, 2022, he was sanctioned by the European Union. He has not been sanctioned by Canada, and we don't know why. The second problem we see is enforcement of existing sanctions. According to the RCMP in June 22, $123,031,000 had been frozen in Canada under Russia CIMA regulations. In December 2022, the most recent data that I could locate, the RCMP reported $122,245,000 in frozen assets. In the intervening 7 months between June and December 22, Global Affairs Canada announced sanctions against 302 Russian individuals and 83 entities. Now, either none of those individuals or entities hold any assets in Canada, or we were simply unable to locate any of those assets. At any rate, $122 million is a comparative pittance to what are likely actual Russian holdings in Canada. In fact, in just one known case, Russian oligarch Igor Makarov moved out some $121 million in assets just days before being sanctioned by Canada in April 2022. The amount a single Russian oligarch was able to move out is essentially equal to the sum total of Russian assets that Canada has been able to freeze. Now, Makarov had been sanctioned by the United States Treasury in 2018, and the reason why our government took no action against him until after he moved his assets out is unknown to us. Now, we understand that this committee intends to conduct a wider study of Canadian sanctions policy, which we welcome and at which we would be honored to provide more recommendations. In the meantime, the UCC reiterates our strong support for Bill S8 and our strong support for ensuring that those sanctioned by Canada are not able to travel here. Human rights abusers and corrupt officials have no place in Canada. And thank you.
Thank you very much, Mr. Zakidalski. We next go to Ms. Lisa Middlemas from the Canadian Bar Association. You have the floor. You have 5 minutes.
Thank you very much, members of the Standing Committee, chers membres du comité. My name is Lisa Middlemas. I'm the current chair of the Immigration Law Section of the Canadian Bar Association. The Canadian Bar Association is a national association of 37,000 members, including lawyers, judges, notaries, academics, and law students, with a 120-year-old mandate to seek improvements in the law and the administration of justice. Thank you for inviting the CBA to comment on Bill S8. Our section believes that the following loopholes should be addressed to avoid innocent people being caught by the broader language of Bill S8. The bill states that a foreign national is inadmissible for international sanctions imposed not only on a country, but also on an entity or person. Broadening the scope of inadmissibility for international sanctions poses a risk by obscuring the delisting process.
There are disturbing examples of instances where individuals said that they have been sanctioned in error. Sanction expert Dr. Charon of the Centre for Defence and Security Studies at the University of Manitoba raised the example of a first or last name spelled differently, if by only one letter. This can result in a sanction for another person. The Canadian Consolidated Autonomous Sanctions List contains more than 3,500 names of individuals and entities sanctioned under the Specific Economic Measures Act and the Justice for Victims of Corrupt Foreign Leaders Act, in addition to those sanctioned under the United Nations Act.
Take the recent reported case of a businessman who is listed on the Canadian Consolidated Sanctions List for collaborating with the Putin regime, although he left Russia over 20 years ago and claims that he has no ties to Russia. His wife was working in another country and claims no ties to Russia either. Given that the delisting application process is complex and lengthy, those who contend they are mistakenly sanctioned have little recourse. When Bill S8 expands the scope of inadmissibility for sanctions, this is of particular concern. And speaking of the lack of definitions for sanctions, it is essential to define the word sanctions, which the bill references in lieu of sanctions for human and international rights violations as presently referenced in subsection 35.1 of the IRPA. S8 expands inadmissibility based on sanctions to include all orders and regulations made under Section 4 of the CIMA. And Section 4 references the Governor and Council making sanctions for a wide variety of circumstances, which in some cases, see subsection 4 1.1 of CIMA, may be premised merely on a decision, recommendation, or resolution. And given the potential breadth for inadmissibility based on sanctions, it is really important to adopt definitions within the IRPA and IRPR. And the lack of definition of entity. S8
creates inadmissibility based on sanctions imposed on a country, entity, or person, yet entity is not defined. The Special Economic Measures Act, for example, defines entity broadly in Section 2 as a corporation, trust, partnership, fund, unincorporated organization or association, and a foreign state. It is difficult to imagine what this concept of entity would not include. We therefore recommend that S8 implement the regulatory framework to ensure that the term entity is clearly defined in the context of immigration law. In addition, the level of ownership and participation in such an entity should be clarified in order to avoid unintended consequences on individuals seeking admission to this country or remaining here.
For inadmissible individuals. Delisting processes vary across international organizations, which complexifies and obscures the process. We believe that it's critical that individuals facing inadmissibility based on the ground of sanctions are independently and impartially assessed. And finally, we would note that inland refugee claimants remain eligible to pursue their claims pursuant to S8, an exception which we endorse. However, we would recommend amending Bill S8 to ensure that a finding inland or overseas that a person is a convention refugee or person in need of protection result in immediate delisting. Otherwise, refugees' opportunity to apply for permanent residence and integrate in this society will be jeopardized.
Thank you very much, Ms. Middlemiss. We now go to our last witness from the Refugee Center. We have Mr. Abdullah Daoud. Mr. Daoud, you have 5 minutes. The floor is yours.
Good afternoon, everyone. My name is Abdullah Daoud, and I'm the Executive Director of the Center for Refugees.
Community, providing a variety of services, including the only full-service refugee legal clinic in Montreal. So far this year, we have assisted over 9,000 refugees and refugee claimants, and we would like to thank this committee for giving us the opportunity to address this critical issue today. Firstly, we applaud the government's effort to restrict bad actors, such as Russian oligarchs, from entering the country, as we have witnessed firsthand accounts at the Refugee Center from Ukrainian refugees of the brutality of the Russian regime. It is crucial for the government to maintain a balance between protecting national security and upholding our democracy, including the fundamental rights and freedoms of individuals impacted by legislation such as S8. This bill goes beyond Russian oligarchs and introduces potential dangers and adverse consequences to unintended individuals or families. We believe changes to the bill must be made. One of the most concerning aspects of Bill S8 is that it currently decouples the term sanctions from violations of human or international rights, thus creating a high level of ambiguity in relation to how sanctions would be applied in regards to admissibility. Bill S8 further connects sanctions to the entire Section 4 of CIMA, such as, and I quote, economic measures imposed against foreign states. This effectively places the burden of economic sanctions solely on individual applicants due to the actions of a foreign government. For example, a Venezuelan foreign national who has invested their money into the state, which is not atypical of a state enterprise such as Venezuela, could be held into account or be deemed inadmissible in Canada. This is why the most important solution we are proposing is to properly define the word sanctions, specifically in regards to Bill S8's amendments in Section 35.11 of IRPA. We believe it should be worded as a foreign national is inadmissible for sanctions on grounds of violating human or international rights. This rejoins the terms with violating human or international rights, avoiding any misuse or ambiguity in relation to broad economic sanctions that individuals cannot be held accountable to. Another issue is that Bill S8's current language places a disproportionate burden on already vulnerable groups. In order to remove themselves from a sanctions list, protected persons would need to go seek out and endure a convoluted and complex legal procedure through Global Affairs Canada. This list has a historical precedent of infrequent updates and is often misaligned with the actions of our international partners. Without specific provisions tailored to address these unique circumstances of these individuals, the legislation may inadvertently jeopardize their safety and well-being. Therefore, we propose to amend Bill S8 to indicate that any refugee claimant that has been found to be a protected person within Canada to be immediately delisted from the sanctions list. Another concern arises from the potential misuse or power granted to the Ministry of Public Safety and Emergency Preparedness and the CBSA under S8. There is a substantial risk of enforcement officials exceeding their authority and making arbitrary determinations related to inadmissibility with little to no accountability. This is due to the lack of a well-defined decision-making framework and removes access to appeals through the Immigration Division and Ministerial Relief. There is no proper history of training in relation to removals based on sanctions within the CBSA, as existing immigration and security infrastructure already addresses such concerns effectively within the Immigration Division. This is further reiterated by the Director General of the CBSA's own testimony when asked about the CBSA's experience with sanctions, as he stated, and I quote, "With respect to sanctions admissibility cases to date, there have been no actual removals because the system has been quite effective in terms of stopping people from arriving in the first place," end quote. Our solution is to amend Bill S-8 in regards to the CBSA in cases where an individual is deemed inadmissible on grounds of sanctions as defined by violating human or international rights. The CBSA should not have the unilateral authority to refuse entry or initiate removal proceedings against an individual without referring the case to the Immigration Division of the IRB. Lastly, the proposed amendments in Bill S-8 may invite challenges under the Canadian Charter of Rights and Freedoms. The denial of access to certain immigration processes and the removal of the ability to appeal or seek ministerial relief may infringe upon the rights of affected individuals, opening the door to lengthy and costly court battles under procedural fairness. In conclusion, by carefully considering the recommendations provided in our brief, we can achieve the dual goals of protecting national security and upholding the fundamental rights and freedoms of individuals affected by our immigration laws. Thank you.
Thank you very much, Mr. Daoud. We will now open it to questions from the members. This first round, each member will get 5 minutes, and we will first go to Mr. Epp. You have 5 minutes.
Thank you, Mr. Chair, and thank you to all of the witnesses for your testimony. I'm going to begin with the Ukrainian-Canadian Congress. You've heard all the testimony from all the witnesses, and as heard from the previous panel, S-8 was reviewed, went through the legislative process in the Senate almost a year ago. I'm going to ask you to comment on speed. I'm going to ask you to comment on the urgency, the concerns that have been raised in the testimony from witnesses that you've heard as well. I assume also went through the Senate, and the Senate made its decisions. So that is also now what this committee is weighing. So can you comment on the urgency on the situation? And, you know, a driver here was the illegal invasion of Russia into Ukraine. The goals of this legislation, I think, is something that we all support around the table. So can you help us with our deliberations?
Thank you for the question. As we've heard, I think that similar witnesses, similar perspectives were heard during the Senate hearing, so I have to believe that those were deliberated on by the senators there and considered as they developed the legislation and brought it here to you. I would say that in the broader scheme of things, the international sanctions regimes are quickly evolving. We see every week, every day, sometimes between Canada and our partners, that there's updates of the list. There's counter sanctions by Russia. I think most of you and me and many others here in this room are on sanctions lists. And the question of enforcement, we've seen tactics like people changing addresses, people transferring ownership of property. These things are moving very quickly. So I think in this environment where the dynamic of time is not on our side, we should be closing loopholes as they are identified and certainly addressing them as quickly as possible.
Thank you. Can you specifically talk about, the Russian oligarchs and their systems? I'll admit I'm not that familiar with their business models. How much of that is family related? One of the concerns we've heard is that family members will be caught up. Can you comment specifically on that?
Well, I think one of the issues is that the models used by these businesses are complex and designed precisely to avoid sanctions regimes. Right. So, whatever trusts and et cetera, there's all sorts of mechanisms that people can use to make sure that the asset held by someone sanctioned is not actually sanctioned. Right. And certainly, we've seen cases brought in the United Kingdom by Russian oligarchs to, get their assets unsanctioned or returned. And I think that, as our legislation evolves, so too do the methods to circumvent it. And so I think, one of the things we'll need to do is to keep up with those methods that the individuals and the entities that we seek to sanction use to avoid the sanctions once they're placed.
Thank you. Mr. Dow, I'm going to ask you to comment because you've raised the concerns that SEMA is too, automatically making it admissibly through the SEMA sanctions makes it too broad for exactly the, so can you respond to the concern that you just heard of the evasive tactics of the oligarchs? How would you respond to that?
Sure. I mean, listen, I'm not a legal expert in this matter, but in terms of what they're referring to, they're talking about assets of certain individuals, and that is a completely different discussion. Here we're talking about foreign nationals and their admissibility into Canada. As far as our concern, in regards to this bill and this legislation, is that we're casting too big of a net. We're going to be impacting a lot of innocent individuals, and we're not talking about assets here. We're talking about individuals' inadmissibility into Canada. We're talking about their relationship and how they could be misrepresented as far as where they're from. Given our population and the people that we deal with, there are a lot of innocent individuals who are trying to come into Canada that are parts of there's a huge list of countries on our sanctions list. I mentioned Venezuela as an example, but there's Syria, there's Yemen. All these individuals are parts of states where they could be tied as shareholders, they could be tied as just having money in their bank, they could be tied to other individuals just by a misspelling of their name, as mentioned earlier. This casts way too large of a net. We're missing a lot of nuances, and I think that's pretty glaring given how fast this bill was put through Senate.
Are you concerned, though, about speed?
I'm concerned about speed without looking over the actual bill. As we have seen from the previous testimony with Honorable Mr. Peter Harder, he said that this was one of the fastest things that they've passed. Typically, when you pass things this fast, it means that you've overlooked a couple of things. We're bringing our concerns, and I think it's well backed with the CBA and with Mario Bellissimo's testimony. He's a kind of a leading expert in this field, that we do need to tweak a couple of things. And we're not asking for a major change. We're asking for simple definitions that I think, if done, could accomplish both goals very efficiently.
Thank you. Thank you, Mr. Chair.
Thank you, Mr. Epp. We next go to MP Zuberi. MP Zuberi, you have 5 minutes.
Thank you, Mr. Chair, and thank you to witnesses for being here in person and by Zoom. I want to start off with Ms. from Canadian Bar Association, and as a refugee immigration lawyer, I should say. I just want to confirm that if the legislation stays as is, that an individual who is named under a sanction list and also becomes inadmissible through immigration pathways because of this legislation still has recourse to the pre-removal risk assessment.
Yes, there's a very limited measure left for PRA, as we would call it, but it removes a mechanism for ministerial discretion as well as oversight by the Immigration Division, which would currently exist for those who are subject to an international sanction. So that provision would be removed. And rather, the person would be left with dealing with Global Affairs Canada, trying to apply for their name to be delisted, and then, or what they call a certificate of mistaken identity, which is a very, from what I understand, complex process.
So to confirm, they would still have access to the pre-removal risk assessment?
That is my understanding.
Okay.
Yes.
And also on top of that, they can still apply to the Minister of Foreign Affairs to be removed from the sanctions list.
Yes, but as I said, I think the trouble with that is I noticed there was a study of this committee in 2017 where there was talk about how that process is very obscure, I guess. Basically, the committee called for more of an independent administrative process because it's hard to know what reason you're being sanctioned for, because there are security partners like CSIS that come up with, why you're on the list. So there's some questions of procedural fairness for people who may allege that they have been erroneously listed.
So do you think those mechanisms for removal should be made more accessible to applicants for removal from the sanctions list, let's say to the Foreign Affairs Minister?
I think that the difficulty with this bill is that it puts inadmissibility in the hands of Global Affairs Canada instead of in the hands of the IRPA. And So I think we have a whole regime to govern inadmissibility that's been in place for 20 years with the IRPA. It's very well adept with treating individuals, giving them procedural fairness while still keeping bad actors out. I mean, we have Section 35, 1C, D, and E that covers CIMA, it covers the Magnitsky Act, and it covers international sanctions for human rights violations primarily. So expanding this inadmissibility regime beyond to international economic sanctions is casting the net quite wide.
I have, I believe, 3 minutes left or so, correct?
No, I'm afraid not. You have a minute and a half.
Minute and a half. I wanted to touch base on what you said. Both you and Mr. Daoud talked about the overbreadth in terms of the lack of the overbreadth when it comes to entity. What is your recommendation about narrowing that definition so that it actually encompasses those who we really are, when they're sanctioned as individuals, there's a robust threshold. When an entity is, which can include, as you said in your testimony, a country, then there is or a government, there is a very broad threshold there. So how do we narrow it so that it meets the threshold for that when we study the individual, that will match it for the entity when it comes to a government in question? So are we talking about leadership? Are we talking about middle management? Are we talking about rank and file? What's your commentary on that?
Right. I mean, I think we'd have to consult a sanctions expert, perhaps like Dr. Andrea Sharon for the definition. But the most important, I think, is to define it within the immigration law context so that individuals are aware what applies to them in terms of whether they can come to Canada or stay in Canada. But perhaps a definition that was a little bit less broad, but still keeps the people that we're trying to keep out.
Finally, I'd like to confirm that sanctions is defined in the other legislations. Although we know that in this specific bill, I should say, it's not defined there, but it is defined in the other legislations in question. Is that correct?
In other legislation, it is. You're right.
When it comes to
I'm
those
afraid you're
sanctioned
out
on
of
a
time,
UN
Mr.
list,
Zuberi.
they cannot remove themselves
Mr.
through the
Zuberi,
Foreign
you're
Affairs
out of
Minister.
time.
Correct? For my last.
Just very briefly respond.
Sorry, I didn't catch
When
your...
those sanctioned on a UN list, they cannot remove themselves through a domestic Canadian mechanism. They have to appeal to international instances, correct?
That's right. They have to go through an ombudsman, quite a complex process, or a focal point, depending on what kind of sanction it is at the international level. Again, a kind of complex endeavor.
We now go to Madame Vignola. You have 5 minutes. The floor is yours.
Good. Merci, Monsieur.
Thank you, Chair. To begin with, I'd like to ask Mr. McAlchishin and Ms. Middlemiss a question. We want to make sure that the right individuals are being sanctioned. And we want to be also able to protect victims of regimes who are here. We don't want to be able to encourage these regimes. My colleague touched upon sections 5 and 6 on inadmissibility. So the definition of sanctions would be broadened. Witnesses have told us that without defining sanctions, this can be problematic. So could you tell us what would be the consequences of improving the definition of sanctions, and what would be the consequences of not properly defining the word sanctions? Microphone. It's very important to define sanctions so that it's clearly understood what is being spoken about. If you look at the Special Economic Measures Act, S8 broadens the 4 types of sanctions. So economic sanctions, for example, can deal with a country's economic actions and corruption. And so individuals who are subject to sanctions based on violation of human rights already are inadmissible. But I think what needs to be defined are the type of sanctions. I would agree with my colleague, Mr. Daoud and Mr. Bellissimo, that we need to look at the context of these sanctions in terms of the violation of human rights. There are various kinds of sanctions. Sometimes it's economic sanctions so that the country changes its behavior. However, there may be individuals who are innocent, who are opposed to, say, the regime, who put in a refugee application, but their name remains on the list of sanctions, and therefore they can't move ahead with their request for permanent residence, for example.
Thank you. Just briefly, I think as was mentioned, we believe that sanctions are well defined in other pieces of legislation, that the scope of those hearings that are coming up, we'll look at those specifically. We agree that we want to protect the victims, but again, the tactics that we're seeing include evasion, transferring property between family members, between shell corporations. So we think that the quickly adapting situation requires this kind of broader scope at the moment.
Earlier, you said that some of our allies have put in place sanctions against certain individuals, yet Canada hasn't. Would Bill S8 change anything with regards to that? Should Canada be following in the footsteps of other countries who have put in place sanctions against individuals? Or should we retain this autonomy when it comes to analyzing these cases? So for Mr. Daoud and Ms. Middlemiss, please.
In that order, or what's the point? Okay. So, and as far as expediting how we put people on the sanctions list, I don't think that's really the purpose of this bill. In terms of whether, in terms of how it's being done now, if you refer to Mr. Bellissimo's brief, he pointed out from security experts that Canada actually has a pretty big leg when it comes to our sanctions regime. So, for example, we've kept countries longer on the sanctions list when our partners and our allies have taken them off. The examples were, I think it was Liberia or Eritrea. So if, for example, we were to pass this and we're casting this big, wide net in terms of economic sanctions, individuals who would have been from those countries, who've had some sort of financial connection to those countries just because of the way they operate, would have been deemed inadmissible. So basing our entire S8 legislation on a sanctions regime that is not quick to act and is from your own recommendations in 2017 of this committee needs a lot of improvement, I think is a kind of a dangerous road to go down to. So again, I would just refer back to our recommendations. They are very minor, I think, fixes that would still achieve and ensure what my colleagues here are also worried about in terms of individuals who are moving around assets who should be labeled and targeted. We actually do work in collaboration with our international partners, so those individuals would probably be identified more by our allies than us first, given how we operate, and we would still be able to use those lists and use, because we do work in concert, that is in the legislation as well, currently under IRPA, with our international partners. So even if this is the case, we would still be able to target these individuals. And lastly, I believe in the Senate debates that we saw when this was being discussed, the CBSA has also said that all the individuals that they've identified that have applied to come to Canada, the 2,000 or 200 or so, I think 25 have tried and all 25 were rejected. So there is a case here in which our current inadmissibility process would cover them.
Merci. Oui, je pense c'est sûr qu'on...
Yes, we should align ourselves with our allies. That was one of this committee's recommendations in 2017. Meanwhile, though, in terms of individuals who may be inadmissible under this bill, where there's a definition,
les sanctions pourraient être très...
these sanctions could be lagging, and it would make it difficult for individuals. Well, you'll be able to follow up in writing if you like.
We next go to MP McPherson. You have 5 minutes.
Thank you, Mr. Chair. Thank you very much for all of the witnesses for being here today. This is very interesting, and I do believe that we are all trying to make sure that this legislation does what we want it to do. I think everybody is on the same page, making sure that the folks that we don't want coming into Canada cannot come to Canada. And I think really what we're trying to get down to right now is that making sure that innocent people are not caught in this. And I took your point, Mr. Dowd, when you spoke a little bit about ministerial, the potential for the exceeding of, I believe you said the exceeding of their authority. We saw this with weaponization of audits through CRA in the past. We've seen this as something that is a considerable risk. And Ms. Middlemiss, I took your comment as well that this is a very complex process if you do want to get your name removed from those lists, if you are erroneously put on that list. And I think one of the things that we heard from witnesses on Tuesday was that it was also an extremely expensive process, considering what refugees, the circumstances many refugees are in. So, I'll start with you, if I could, Mr. Dowd. Can you explain in more detail the experience of a refugee who may face challenges as a result of this bill? And in particular, are the recourse mechanisms costly, including judicial review, and how do vulnerable refugees approach that kind of challenge?
The population that we're dealing with, they are not very aware of these mechanisms. You need to have a certain level of knowledge to know what's available to you. So let's take an example, like I could say a Venezuelan or Iranian person who's a foreign national who has come to Canada, claimed asylum, has went through the entire process. They've been found to be a protected person. However, in the process in which they're applying for a permanent residency, due to some sort of economic connection to the state, let's say, for example, an Iranian individual, they are forced into a lot of religious schools. A lot of those religious schools are considered entities sometimes that we would include under these lists, to no fault of their own. They could have been identified and banned and put and denied permanent residency. And then the legal avenues for them to do anything about it is a judicial review, which is, we have a legal clinic and we have a couple of lawyers, and we try to take on as many cases as we want, and we work a lot of time on pro bono, if not almost exclusively on pro bono. $500, $600 stipend for a lawyer to do 120 hours worth of work is not reasonable, and I don't think is a reality that they can afford. And I'll leave those legal questions more to my colleagues. However, also getting their name off the sanctions list is also a very complicated process. And again, coupled with the fact that our sanctions regime isn't always up to date and is always lags behind. Let's say, for example, historically given, we left Eritrea on that list. If they were to, for example, try to take their name off the sanctions list, although all of our allies have agreed to take them off the sanctions list, and we kept them on, they wouldn't be able to. So we have a lot of working mechanisms here that aren't up to date, that while we include these challenges and rely upon non-up-to-date mechanisms, could cause a lot of problems.
Thank you. I don't want to forget our colleagues that are online. Mr. Colguy, I will ask the next question of you, and I did just want to express once again my sympathies for your friend, Mr. Kara-Mirza, and his family on the horrendous decision to charge him with 25 years for a crime he has not committed. But the question I have for you, can you tell us more about the need for greater engagement and communication with Canadian civil society groups that are involved with human rights and democracy advocacy, including those who can best identify the foreign entities that should be placed on Canada's lists? And are there any amendments that you would want to see to this bill that would facilitate that? Mr. Mirza, or Mr. Colguy.
Thank you so much for the question. Yes, I do believe that the government could engage more closely with human rights organizations, civil society groups that are tracking human rights violations around the world, and also working internationally to harmonize our sanctions with our allies, some of whom have close relationships with those civil society organizations. These people know best who should be targeted by those sanctions. And so, again, closer coordination would be greatly welcomed. And I think that specific amendments, this isn't. This point doesn't speak necessarily to S8, but to the our broader sanctions regime. But ensuring some form of transparency and accountability. And in the United States, for example, the U.S. sanctioning legislation, their Magnitsky Act, requires the U.S. government, the executive, to produce an annual report to demonstrate how U.S. sanctions have been used, who they've been targeting, why they've been targeting specific individuals and entities. I think that this is something that would be extremely useful in Canada as well to help guide our sanctions and to better make them more efficient and in the long run.
Well, we will look at that during the sanctions study. Thank you very much.
Thank you. We now move to the second round. During the second round, each member will be provided 4 minutes, and we start with Madame Crampa-Nyman.
Perfect. Thank you, and thank you to the witnesses. I'd like to begin my comments or my questions to Mr. Kolga, a familiar face after sitting. I sit on national defense as well, and I know you've been a familiar face at that committee. So over the last couple of days, as a member of National Defence, I've also met with delegates from numerous Eastern European nations, Poland, Latvia, Lithuania, and Moldova. All of them have reiterated the importance of a strong military in the face of Russian aggression. In your opinion, how important is it for a country to also have a strongly defined sanctions regime to help hold the aggressor nations accountable and our country safe?
Well, thank you, Mr. Chair, for that excellent question. It's extremely important that we have a strong sanctions regime. And I think, quite frankly, over the past 15 months during Russia's barbaric invasion of Ukraine, I think Canada has demonstrated international leadership in terms of sanctions and applying those sanctions on members of the Putin regime and more broadly on the Russian government. The sanctions, I believe that, and I think a lot of other experts believe that they have been effective. They've certainly deterred as far as sanctions on export of technologies, dual-use technologies and such. They have hampered Vladimir Putin's ability to repair the weapons that have been damaged over the course of this war and to upgrade and build new weapons. And this is certainly, I think, given Ukraine an upper hand over the past 15 months. And as far as deterrence is concerned, I think that we're seeing the effects of the sanctions. We're seeing cracks appearing inside the Kremlin. There have been numerous reports of oligarchs that are close to Vladimir Putin questioning the logic of his decision of going to war and invading Ukraine. I think that sanctions were seen at the beginning of the conflict as some sort of a silver bullet that might stop the conflict, but they're not. It's a form of medicine. We need to sustain these sanctions. We need to continue applying them because it's a strong form of pressure. And like I said, I think the pressure is showing on in certain areas, certain parts of the Kremlin. We can, like I said, we see some of these cracks appearing. So we need to keep the pressure up, work with our allies, further coordinate those sanctions, and make sure that those loopholes that do exist within our sanctions regime, that they are closed. The ones that I mentioned in my opening remarks, specifically with regards to Russian state media, for example, we need to make sure that those loopholes are closed.
Excellent. Thank you. My next question, gentleman from Ukrainian Canadian Congress. It's obvious that the legislation is extremely topical given the Russians' illegal invasion of Ukraine, and I assume that this has played a role in the development of the bill. However, here we are a year later, after the bill is passed in the Senate. So do you feel that the developments in the conflict has warranted perhaps strengthening of the legislation? Is there a way we could strengthen it?
I mean, I don't have any specific recommendations on strengthening this particular legislation. We have several recommendations on how we could strengthen our sanctions regime, which we look forward to giving to the committee. I mean, I can talk about it now, but I think we're
No,
a bit afield.
perhaps if you could just provide that to the committee, and then I'll move on to Ms. Middlemiss.
Very briefly, Mr. Zakadowski, please. You have maybe 10, 20 seconds.
Fair enough.
Samir got an extra minute. We should give it.
Do I have a moment just to pose Ms. Middlemiss a question?
Well, you're out of time, but yes, but very, very briefly, if we
It's
could
not
make
very
sure
brief,
the
so I'll,
question and the
I'll leave
okay.
it to the next round. Thank you.
Oh, sorry about that. Thank you. We next go to Mr. Oliphant. 4 minutes.
Thank you, Mr. Chair. I particularly want to ask Ms. Middlemiss and Mr. Bellissimo about your experience as legal advisors in removing people from our sanctions list. You both spoke extensively about the problems in the system, and I'm just wondering about your expertise in that area and your experience in the number of cases you've had of people you've removed or helped or been unsuccessful in removing from those lists. Mr. Chair, Mr. Bellissimo.
Would you like me to begin?
He's waiting.
Yes, of course.
Should I speak? Yep.
Yes, Mr. Bellissimo, please proceed.
Oh, sorry. Yeah, so thank you for the question. The reality is that immigration lawyers are not dealing with individuals that have been sanctioned because, as you can see from the testimony, it's just not come up in 20 years. The system is quite robust now. And the dangers of what I'm discussing is, you know, in the 26 years, in seeing what legislation falls for constitutional challenges or for other reasons and ends up getting struck down, is because what happens is there's almost an echo chamber. There's a lot of emotion, there's a lot of energy, and there's an issue that you can almost get into a situation where targeting the bad actors, which we all agree we want to eliminate, but by going so far, those bad actors suddenly have legal options available to them because the law is so broad and so vague, and suddenly the law...
Thank you. Because my time is limited, Ms. Middlemiss, do you have a comment on that?
Yeah, I mean, I think it's very rare, as Mr. Bellissimo says. Like, we heard in testimony yesterday as well. I believe in Senate, one of the government officials said that only 25 individuals had applied for a visa and then had been found to be inadmissible for sanctions. And so it hasn't come up a lot yet. But if it does come up, because we're talking about an expanded inadmissibility regime, I believe it would probably look like a very cryptic process where you don't know the evidence in front of you, sort of similar to cases of security.
Thank you. And I'd just like to use my remaining minute to give a shout out for our officials at Global Affairs Canada. That fear they may have sensed they were maligned today. The sanctions regime in Canada, as I think Mr. Colga said, is one of the most profound in the world, and it is different. Every jurisdiction has a different legislation. We have 3 pieces of legislation, and we have a committed group of officials who diligently investigate. They do it in partnership with allies, Mr. Chair, but they also do it on recommendations from civil society, but it's not a majority vote. It's not as though people come as neutral players and suddenly say someone should be on this and they get on the list. That's not the way the public service works. They take very seriously their responsibilities, and they equally need to do it when someone is removed from the list. I think we will have a sanctions study that can look at that process, but I just wanted to make sure that they didn't feel that somehow this committee was saying that they were somehow failing in those duties. I think our activities, particularly since Russia's illegal invasion of Ukraine on Belarusian and Russian autocrats has been fantastic. So I just wanted to get that on the record. Thank you, Mr. Chair.
Thank you, Mr. Oliphant. We next go to Madame Vignola. You have 2 minutes.
Merci beaucoup.
Thank you. We've been talking about inadmissibility for reasons of sanctions against countries or individuals, but this seems to be rather broad. How could we make sure that it's not too broad, in fact, in reality?
I think we just have to follow the recommendations put forward by Mario and the CBA and myself, is just define the terminology so that we're targeting individuals. Once we go to 35.11, in which I've stated that it should be defined as far as we believe it should be worded as a foreign national is admissible for sanctions on grounds of violating human or international rights. This rejoins the term back to what it currently is and takes away the broadness and ensures that we're not casting a big net. And hopefully that would push forward. I would probably push the question towards my colleagues as well.
Merci. Ma prochaine question.
Thank you. My next question is for Ms. Middlemas. Under the CIMA and the Magnitsky Act, a foreign country is defined as being a country other than Canada. And then there is reference to its political administration, its governments. I'd like to know whether that definition needs to be amended. Just because you are from a foreign country as currently defined means that you may be denied entry. No, you may be inadmissible. Am I right?
Again, I'm sorry, it's already been 2 minutes, so if you could condense your response to no more than 20 seconds, please.
Under Bill S-8, all types of sanctions against countries, including economic measures, would be covered.
Go to Madam McPherson. You have 2 minutes.
Thanks very much, Mr. Chair. Again, thank you to the witnesses for being here. Your Norris, I have a question for you, for UCC. One of the things that we know is that we have a problem with not just making sure people that are sanctioned don't come here, but also dealing with folks that are already here. I know that it's been brought to our attention that there are 81, I believe, Russian diplomats and diplomatic staff that are still in Canada, and yet only 25 are from Ukraine. Mr. Oliphant has said that our sanction regime is amongst the best in the world, but I would argue that perhaps the enforcement, perhaps the transparency, the clarity is not top of the line. Could you maybe comment on that?
Thank you. On the issue of expulsion of Russian diplomats, our position is that we should be closing all of the Russian missions, the 81 people, and it's up to Canada to decide how many Russian spies we want to have in Canada. And we've been making that point that they're not here in benevolent work. Our NATO allies, EU allies have expelled hundreds of these diplomats, quote unquote, and we know that they are here fomenting online and real hate against parliamentarians and against our democratic institutions and our community.
Yeah, and certainly against members of different community groups as well. Yeah. Mr. Soldowski?
I mean, on the point of sanctions methodology and enforcement, the short answer is we don't know why some people are left off of our lists. So that I think would be a question put to officials and to the minister. But we certainly don't understand why some people have been left off that have been sanctioned by our allies. And in terms of enforcement, I think part of what we hope that your upcoming study looks at is what kind of resources are needed by the RCMP and other enforcement bodies to indeed find any assets that are here and freeze them and hopefully seize them soon and turn them over to Ukraine for reconstruction.
Thank you, and that is why I brought that study forward, so that we could actually get to the bottom of some of that. Thank you.
We next go to Mr. Epp. Mr. Epp, you have 4 minutes.
Thank you, Mr. Chair. I'm going to begin on line with Mr. Bellissimo. And specifically to the 5th recommendation that you brought forward, I believe that was put forward by the CBA, specifically that states that a Canadian refugee determination, whether inland or abroad, should lead automatically to the deletion of the name of a person from all sanctions list. What I'm going to ask you to do is comment what you might feel the impact would be on irregular immigration into this country. Would that slow it? I mean, immigration is something that we all support around the table, but ordered immigration. Can you comment, please?
Thank you for the question. It's a recommendation actually made by Mr. David Mattis. The impact on irregular arrivals, given the amendments of the Safe Third Country Act, would now be minimal at best. I think the issue with the delisting is, even though there's access to refugee status, there is no access to any sort of status, be it temporary or permanent, until you're delisted. So those individuals remain in a state of legislative limbo, and that, practically speaking, would be very difficult moving forward. And I think it's a part of the bill that hasn't embraced the actual next step of what happens when someone is able to make a claim but not seek any sort of status while remaining in Canada. Thank you.
I'm going to cede the rest of my time to my colleague, Mr. Hoback, but just before I do, I'm going to make a statement that, you know, I'm wrestling with the balancing of security and safety concerns with some of the legitimate concerns that we've heard today. We heard from the testimony from the Senator this morning that speed and urgency was behind pushing forward S8. That's why it was introduced in the Senate. And yet I have to ask myself why it's been a year since that process till we face with it now. And I feel the sense of urgency for the situation in Ukraine, but I will acknowledge some of the concerns that I've heard from other parties. Mr. Hoback.
You have 2 minutes remaining, Mr. Hoback.
I'm just kind of curious. I asked the senator in regards to a removal of certain sections and then relationship to human organ trafficking, and he said, well, that was encompassed in other part of the bill. And I'm not sure if it'd be you, Ms. Minimus, to best answer this. When it comes to human trafficking, is the terminology changed in such a way? Is there a justification for removal out of this piece of legislation?
From my reading of this bill, I don't believe that this would have any impact on human trafficking, inadmissibility for human trafficking.
So you're comfortable with the reduction, the removal of that paragraph then?
Yes.
Okay. And then, Mr. Duad, you talked about there's some amendments that you'd like to see, just slight amendments that you think would be good. Could you table those amendments to this committee so we'd have a copy of those?
Yes, for sure. I can send it to you right after.
Okay, just so we have a chance to see if there's something we can consider or not. Don't mind. And then one thing I also noticed, there's nothing in the act that talks about people with PR. So the permanent resident, they're not Canadian citizens, but they're not tourists. So have we addressed that issue properly within this legislation in regards to people with PR status?
I don't think we really have addressed that fully in the bill, we also we don't really understand the full implications for citizens either under the revocation provisions that are proposed. So permanent residents have obviously very important rights in this country, so it is important to know how they would be impacted, and also citizens who it would be nice to see a little bit more fleshed out in the regulation or the proposed regulation so that we could understand the mechanism.
The problem with regulations is we don't get to go back and look at them or change them here in the committee. That's the government and the bureaucracy that will put forward the regulations. Now we can critique them,
right,
and we can study them afterwards, but it doesn't mean it's necessarily allows us to change the legislation to reflect a bad reg or a good reg. Is there anything else in implementation of the act that concerns you? Okay, never mind.
Thank you. And for the final question, we now go to Dr. Fry. Dr. Fry, you have 4 minutes.
Thank you very much, Chair, and I want to thank everyone for coming and really flagging a whole lot of things that, as my colleague said, we really need to look at the balance between security and human rights and individual rights. So thank you. This is a very interesting conversation. But I wanted to go to the Canadian Bar Association. I also wanted to welcome Mr. Colga because we worked on Magnitsky together a long time ago. So what I want to do is the Canadian Bar Association flagged that the referenced country really does become too broad a net. That, in other words, we are struggling with it here. We look at what's happening with China. We look at the disinformation. We look at the foreign interference question. We don't want to say the Chinese are not admissible to Canada. So how do we balance and define that so that we do not, and I know you have to name people on the sanctions list, but how do people inadvertently not get into that particular trap because they come from a particular country, say like Belarus or like China or Russia, who may or may not be ordinary citizens, and who may have similar names, or who may have relationship to somebody that has nothing at all to do with government distinction and government deliberations. How do we do that? I've heard a lot of people suggest things. It's just somebody with a nice, clean recommendation. Mr. Bellissimo, it looks like you're ready to put your hand out. Go ahead.
Thank you. I think, and it's an excellent question, it has to be tied again to grounds of violating human or international rights. Any individual that is sanctioned, there has to be a direct link. It cannot be separated as a standalone sanction ground because of geographic location or country. I think that is a step backwards in the legislation that we currently have in place. And I would caution everyone to be careful moving forward on that basis, because it might be 3 steps backwards rather than a few steps forward.
So you are recommending that we define that a little bit better in the legislation?
Yes, that it remains currently, a sanction is tied to grounds of violating human or international rights. For some reason in this bill, it's been divorced, it's been decoupled, as my friend said from the Refugee Center, and I think that's risky in law in terms of enforcement.
Okay, well, thank you very much. And now people have talked a lot about redress. If your name is on a list and that you're inadvertently there and that you want to take the name off because you're John Smith and there are hundreds of John Smiths around the world and you just happen to be named John Smith. Now, the minister told us at the meeting that there were ways to redress that problem, that you could go to GAC, that you could get relief at the federal court, and that there is, for people who do not have money or the means with which to address those things, that there is money being put into legal aid to help them to have access to that kind of justice. Do you think that's sufficient? Do you think there is something else that can be put into place? Mr. Bellissimo, but I'd like to hear from Mr. Colga.
But just very quickly, I'll add, I think you need to leave safety valves in place where there are innocent individuals, should have more immediate redress within the IRPA, ministerial relief, access to the Immigration Division. I think those safety valves are important both for the constitutionality of the provisions and for ease of reference. Again, we want to get the bad actors. Thank you.
Thank you, Mr. Bellissimo. Give Mr. Colga the last bit of time I have. I don't think I have a lot.
I'm sorry, you just have 8 seconds remaining, Dr. Fry.
We need to be very sure that we're not inadvertently creating loopholes that will be exploited by these Russian oligarchs, others that are targeted by those sanctions.
Thank you very much. Thank you, guys.
Very much. So I would like to take this opportunity to thank all of our witnesses for having been here for their testimony and answering all the questions posed by the members. Thank you, Mr. Bellissimo. Thank you, Mr. Colga. Thank you, Ms. Middlemiss. Thank you, Mr. Mikalchishin. Thank you, Mr. Zakidalski. And thank you, Mr. Daoud. Very grateful indeed. Is it the will of the committee to adjourn? And just a reminder, on Tuesday is clause by clause for S8. Thank you.